Let's discuss some of the case studies regarding the articles in the Code of Ethics. Article 1 is there to protect and promote your client's interests. This obligation is your primary obligation, to treat all parties fairly. The standards of practice under Article 1 and 1-2 determine the actual definitions of clients, customers, agents, and brokers. Please read through the case study on pages 20 and 21, break up into some small groups of 5 to 6 people, and discuss the questions on page 21 of your guide. Please pause this video and resume when you've completed this. This should take no more than 8 minutes, and we will discuss your answers when you return. Welcome back. Let's see how well you did. Question number 1. Realtor Leo's obligation under Article 1 calls for him to... The answers are B and C. The agent is required and supposed to put the clients first rather than subordinating his interests above that of the client. So he is required to show Dr. Newcomer all properties that meet his specific needs and requirements, regardless of whether those properties are listed with Done Right Realties or another firm. He should subordinate his interests to those of Dr. Newcomer. Question number 2, a true and false question, asks, is Realtor Leo responsible to disclose the $1,000 bonus that was offered by his firm when he enters into the exclusive buyer's representation agreement with Dr. Newcomer? The answer here is false. There's no actual obligation established in the Code of Ethics to disclose the $1,000 bonus. However, nothing prohibits Realtor Leo from doing so to fully inform his client and to eliminate the potential for future problems. Regardless, Realtor Leo must put Dr. Newcomer's interest before his own desire to obtain the $1,000 bonus. Further, Standards of Practice 1-13 does not apply because the $1,000 bonus is part of an in-house incentive and not from other brokers. If a second offer were submitted for the property by another real estate office at the same time as Dr. Newcomer's offer was submitted, what disclosures to that cooperating broker, if any, would Done Right Realty be required to make? The answer here is the existence of Dr. Newcomer's offer and that was obtained by another licensee within Done Right Realtors, but only if asked by the cooperating broker and given the approval to do so by the seller. Article 2 deals with exaggerations. It might be represented as a disclosure article. It requires more than simply disclosing property defects. It also talks about avoiding exaggerations, misrepresentation, and concealment of pertinent facts about the property and/or the transaction. Realtors are not required to be experts in every possible aspect of real estate transactions. For example, Article 2 makes it clear that realtors may not be home inspectors, professional engineers, architects, accountants, attorneys, or the like. These areas would generally be considered to be outside the scope of a typical real estate licensee's expertise and not required by the licensee's statute. However, realtors have an obligation to be aware of conditions and matters which a reasonably knowledgeable real estate license in the state or locality would know. In other words, a realtor cannot ignore a condition of which he or she is aware just because he or she believes that the home inspector might also note that condition. Realtors should make the appropriate disclosures to the appropriate parties of the information which the realtor is aware of at the time. Article 2 does not require the discovery of latent defects or those that are hidden. Please read through the case study on pages 23 and 24. Break up into groups of 5 to 6 people and discuss the questions on page 24 of your guide. Please pause this video and resume when you've completed. This should again take no more than 8 minutes, and we'll discuss your answers when you return. Welcome back. How did you do with this article? Is Realtor Dean in violation of Article 2? The answer is C, yes. Because Realtor Dean is obligated to discover and disclose the adverse factors that are reasonably apparent to a licensed real estate professional, obviously a little due diligence would have been prudent and avoided this situation. How should Realtor Dean have responded when he was asked about the new construction? Answer here is B. Explain that although he didn't know the answer, he would research it and get back to Bert. Let's move on to Article 12. Also known as the True Picture Article. Article 12 requires realtors to present a true picture in all of their real estate communications. This true picture includes communications of advertising, marketing, and other representations. In short, a true picture is truthful and accurate advertising, marketing, and other representations by a realtor. Another important component of the true picture test for realtors is disclosing one's status as a real estate professional in all advertising by using the term realtor, realtors, realtor's associate, or by disclosing one's status as a licensed broker, appraiser, property manager, salesperson, etc. The true picture test also applies to websites of realtors, realtor firms, and all affiliated licensees, and to their domain names and URLs. For instance, Article 12 requires realtors to remove outdated information such as expired listings from their websites. The article also bars the use of misleading internet domain names, including the use of competitors' names or firms. Additionally, Article 12 governs the use of for sale signs on property. Please read through the case study on pages 26 and 27. Break up into groups of 5 or 6 and discuss your questions again on page 27 of that guide. Please pause this video and resume when you've completed. It should take no more than 8 minutes again, and we'll review your answers when you return. Welcome back. Let's look at the answers to the questions regarding Article 12 and the first case study. Which standard of practice applies to this situation? The answer here is D, Standard of Practice 12-12. Has Realtor Bob violated Article 12? Yes. Obviously, using your competitor's name in your URL is a blatant violation of Article 12, as he is not advertising his company and misrepresenting the advertising completely. Article 12 case study number 2. Please read through this case study on pages 28 and 29. Break up into your groups of 5 or 6 people and discuss the questions on page 29. Please pause this video and resume when you've completed the answers. This should take no more than 8 minutes. We'll discuss the answers on your return. Welcome back. Let's get right to the questions. Is Realtor Sloan obligated to keep his company's listings information up to date on his firm's website? The correct answer is A, yes. He is obligated to keep his website current. Then how long does Realtor Sloan have to remove the outdated information or expired property information from the site? The answer is actually both B and C. Realtors should use reasonable efforts to ensure information of their websites is current and accurate. It also depends upon the multiple listing services IDX rules and or VOW rules. When he took the listing, Realtor Sloan received permission from the seller to post a sign on the property and to advertise it on his website. Such authority remains in effect even after the listing expires. Is this true or false? The answer here is false. That opportunity to advertise the property dies with the date of the contract. Let's move on to Article 7. Realtors' principals may arbitrate contractual and non-contractual disputes. Arbitration is a privilege and an obligation. We've already discussed that Article 17 requires realtors to arbitrate disputes with other realtors and with clients. Those clients who have requested arbitration and agreed to be bound by the decision. An arbitrable issue can include contractual disputes, certain non-contractual disputes as defined by Standards of Practice 17-4, and under Article 17, arbitrarily stems from those having successful transactions, which is defined as a property that has closed or a lease that has been executed. Arbitration typically is used to settle disputes between realtor principals of two different real estate firms concerning entitlement to a commission or to cooperating brokers' compensation. Entitlement is determined by an arbitration hearing panel and an association's professional standards committee based on determining which property is or party is the procuring cause of the sale or lease. During an arbitration hearing, the determining standard of proof is the preponderance of evidence presented by parties defined by statement number 26 of the Statement of Professional Standards Policy applicable to ethics proceedings in the NAR Code of Ethics and Arbitration Manual, as evidence which is greater weight or more convincing than the evidence which is offered in opposition to. Evidence which as a whole shows that the facts sought to be proved are more probable than not. Once a matter has been arbitrated by an association of realtors, neither party may initiate a later arbitration before a different association based on that same issue. This is our last case study on page 31 and 32. Please break up into your groups of 5 or 6 after reading this and discuss the questions on page 32. Please pause this video and resume. It'll take no more than 8 minutes, and we'll discuss the final answers when you return. So, under Article 17, does filing litigation against another realtor over a contractual dispute always lead to a violation of Article 17? Your answer C is correct. It depends on whether a request for arbitration has been filed. The grievance committee determines the matter as an arbitrable and or mandatory nature. And lastly, a separate ethics complaint alleging the charge of Article 17 has been filed. Realtors may be relieved of their obligation to arbitrate through the local association of realtors when, and the answer here is all of the above. A grievance committee or hearing panel find that the matter to be legally complex or too legally complex, or the amount involved is too large or too small. Also, both parties voluntarily choose to litigate rather than to arbitrate. The arbitration is classified as voluntary by a grievance committee, and the request of arbitration is filed after the filing deadline. Our third and final question is, failing to pay an arbitration award always a violation of Article 17? The answer here is B, only if a pattern of refusing to pay those arbitration awards is actually established. While we also only discussed 4 of the articles in today's Code of Ethics training, we encourage that you read and understand all 17 of the articles and be familiar with their interpretations. There are additional video segments available online at www.realtor.org/code videos. Remember, the Realtor Code of Ethics protects the buying and selling public and the general public, promotes a competitive real estate marketplace, enhances the integrity of our profession, is our promise of performance, and is our promise of professionalism. Thank you for listening today. You've completed your quadrennial Code of Ethics training.